Hi, this is Shep Altschuler, publisher of TimeSharing Today. Welcome to TST Broadcasting, featuring news and views of owners and industry professionals. Today's TimeSharing Today radio's broadcast will have three segments, each dealing with the long-standing investigation by New York's Attorney General Eric Schneiderman into wrongdoing at the Manhattan Club. Several weeks ago, I spoke with Doug Wasser of the law firm Wasser-Russ following the hearing in which several motions were filed by the defendants in the investigation. Doug represents over 24 owners of the Manhattan Club. He acts as liaison for them with the Attorney General's office, and he will be commenting on the March 11th hearing. We will then be joined by investigative reporter Jeff Weir, who this past week received the results of the March hearing from Doug Wasser. Jeff and I will be discussing the significance of the judge's ruling. Our final segment will be with New York attorney Lowell Sidney, who recently filed a new class action lawsuit against the developers of the Manhattan Club. So let's begin my conversation with Doug Wasser. Hi, Doug. Tell us about the group you represent and the March 11th court hearing.
Sure thing, Shep. So I represent a group. We've now grown to 27 unit owners, having somewhere in the neighborhood of 32 or 33 units in all. And what I do for them is I try as best I can to keep them up to date on the Attorney General's investigation. I try and liaise with the Attorney General as well. And the group acts as kind of eyes and ears to kind of feel out important facts, important developments, and we try and communicate that to the Attorney General and try and get the Attorney General to act on developments as they arise. The Attorney General is conducting their investigation, and we get snippets of it, and that it breaks out in litigation in the New York courtroom. There was a motion made by the sponsor parties, Eichner and Lager and all, to expedite the Attorney General's investigation and to get Eichner removed as a subject of the Attorney General's investigation. And that motion finally came to be heard on March 11th, and I was present at that argument. I said to my group, it was like watching a prize fight with seasoned boxers trading body punches. I think the Attorney General got the better of it, but this is a fight to the finish, and it's going to go on for quite some time. This is hardly some stale, bureaucratic, non-movable thing going on here. There's a lot of energy going into this, and it's going into it from both sides. One thing I was encouraged to hear was that the Attorney General announced when they get around to take the depositions of the sponsor parties, they intend to file formal complaints against the sponsor parties. So in other words, they intend to move beyond the investigative phase and actually move to a more prosecutorial position against the sponsor parties.
Okay, so Jeff, let me ask you about this recent court ruling in New York and the investigation that's ongoing with the Attorney General. Could you provide some detail about this recent court ruling and its significance?
Shep, I'd be happy to. The court ruling came out on May 26th, following 2 full years of investigation by the Attorney General into a variety of business practices that were bothering owners at the Manhattan Club. And the decision on May 26th by Judge Eileen Rackauer in New York is easily the most significant in this case so far. There were numerous motions before the judge that were designed by the defendants, who are the developers of the Manhattan Club, to terminate the Attorney General's investigation, to dismiss some of the key defendant developers from the case entirely, to avoid sanctions for potentially not cooperating fully with the Attorney General on their investigation of legal documents. And when it was all said and done, the judge rejected every single one of the motions proposed by the defense team and upheld all of the motions proposed by the Attorney General. And the reason it is significant is this: if the developers, who were led by developer Ian Bruce Eichner, if they had won on these motions, the Attorney General's case would have been largely gutted. And the reality is they would have had to appeal this ruling if it had gone against them. Because what the defendants were trying to do, in effect, was limit the continued investigation by saying 2 years is long enough. The Attorney General should put up or shut up after 2 years and either file a civil fraud case against the defendants in the timeshare business, or they should drop their case. And that's why it had a significant moment in time. And frankly, in 2 years of many legal wranglings back and forth, this is only the first major court decision that has become public. And for people that are, trying to catch up on the Manhattan Club case, it's one that started several years ago with hundreds of owners filing complaints with the New York Attorney General's office, claiming that they were unable to use their timeshares, could not make reservations. Their maintenance fees were increasing dramatically, and they were feeling shut out of their valuable club in Manhattan. And as the Attorney General started looking into what actually had been going on there, they sent in undercover operators who investigated the timeshare sales pitches. They tape recorded all of those sessions, and that led to an ex parte court order in July of 2014 where the Attorney General persuaded a judge to shut down the Manhattan Club timeshare operation completely, to freeze all bank accounts, and to launch a major civil fraud investigation of all the key players that were running the club. Since that time, we have thousands of Manhattan Club owners who are in what I would call total limbo of not knowing what will happen to their timeshare, not knowing whether they should pay maintenance fees of $2,500 a year on average, and not knowing whether they'll ever be able to use the club again.
Now, I know that you've been in touch with Doug Wasser. What was his comment to you about the ruling?
Well, Doug's comment was very straightforward. He said this was a slam dunk victory for the Attorney General, an outright loss of major proportions for the Eichner developer side. And he also expected that there might very well be an appeal of this case, because the underlying issue so far is whether the Attorney General had legal authority to shut down the club in July of 2014. And according to Doug Wasser, that issue has not been fully litigated at the appellate court. And the question really is, from a legal standpoint, what level of evidence do you have to have before you can go to court and shut down a business? And so Doug is fairly confident that there will be an appeal of this by the Eichners, and their legal team is very well suited to do it, because they are a very capable group of attorneys, and they have been very aggressive in filing motions and pleadings and briefs back and forth for many months now in objecting to literally, from my standpoint, everything the Attorney General is trying to investigate.
Thanks, Jeff, for this important update. Now let's turn to Lowell Sidney. Lowell, please tell us about the class action lawsuit that you filed.
Sure. Thank you, Shep. Yes, I'm still getting up to speed. I'm getting there after reading several of the filings of the Attorney General action. I've also read some of the previous class actions that have been dismissed for various reasons. What I did before I drafted this class action was I looked at, I believe there were three. I looked at the complaints, I looked at the motions to dismiss, as well as the order granting the dismissal, and then I drafted my pleading, for lack of a better phrase, a little more carefully to avoid the same fate. This is a very simple case at its heart. I think that everyone who's listening to this and everyone who's contributing today knows this, that it's our allegation that the sponsors, the Manhattan Club, the Eichners, let's just refer to them as Mr. Wasser called them the sponsors, they oversold something that they didn't have to sell. I've heard a number as high as 18,000, perhaps more. When it's simple math, if you just do cocktail napkin math, it looks like they had about 12,000 to sell. So obviously what happens is if you have only 12,000 students to sell and you sell 18,000, what happens is what we have here, that not everyone's able to use their week as promised. And then further what happens is when people can't use their week, they decide, well, why am I paying maintenance fees for something I'm not able to use? So they drop out and default. And then the rest of the existing members are now carrying their weight, and their fees go up. It's a downward vicious cycle, because as it goes up, the fees go higher and higher. Now I believe it's $2,700. Anyone who knows New York real estate or New York hotels knows you could stay at pretty much any hotel you want in New York for $2,700 a week. So there's really no benefit to owning one of these units. Further, if you know New York real estate, people bought these units 20-something years ago. Anyone who bought any property in Manhattan 20 years ago has doubled, tripled, quadrupled their investment. What we have here are people who invested, let's just say, $25,000, and it's worth nothing. I've spoken with defense counsel, and their position is, well, the members are exaggerating, that there's really been just a few members, and they've been resolved, their issues were resolved accordingly. Clearly, he's drinking the Kool-Aid because he can't really believe that. I believe it's disingenuous to say that, I've received about 500 communications from various class members or Manhattan Club members. They all, had the same common thread. So I would tend to believe 500 people over his one client. And the other difference is the Attorney General isn't investigating the class members. They're investigating the Manhattan Club. And, as Mr. Wasser also pointed out, it's turning more prosecutorial. I believe that, the Eichners might have insulated themselves in terms of criminal liability, but it really is largely irrelevant to the civil action, because even if they were unaware of criminal activity below them by, let's just say, a rogue sales team, it doesn't matter because the Eichners eventually benefited from that fraud. So in a civil case, it really won't be a defense that they were unaware that there was this inventory overselling.
Now, I have a question. Why do you feel that this lawsuit will stick and not be dismissed, and why it would be certified as a class act?
Okay, well, I believe it will stick because, like I said, I think I've carefully pled it so that it won't be, previous actions that were based on the fact that the Manhattan Club was using it, the hotel as a hotel, and the Manhattan Club, whether you believe it or not, were able to argue that they were using that as a marketing tool to sell units. The theory being, someone stays there, has a lovely time, and then they want to buy a week. And the court bought it. This time, we're not arguing that it was wrong for them to use it as a hotel. I'm just simply arguing that they sold something that they don't have. It's a simple case. I think that, we satisfy all the factors here. In terms of class action, there's typicality, commonality, numerosity. I think it's manageable. I think there's approximately 18,000 class members. It just seems like a judicial use of economy. So, that's, and that's, I don't want to get too deep into it, but I believe it's a pretty simple action that it just lends itself to being a class matter.
Right, and just to ask one more question, would there, because of the investigation by the Attorney General, will this impact on your ability to take discovery in this class action? No,
I think that it will actually help rather than hinder. Many of the discovery issues that would be common in these sort of matters will actually be resolved by this AG action. So I think it will be much of a problem.
Thanks, Lowell. We'll be very interested to see how this lawsuit progresses. Clearly, the process has been long and painful to the owners impacted by the investigation, and TimeSharing Today will continue reporting new developments as they occur. We appreciate the information provided by our guests, and if you would like to contact them, you can email Doug Wasser at doug@wassruss.com. That's doug@wassruss.com. Jeff Weir at jeff@redweek.com, and Lowell Sidney at Lowell, Lowell at Sidney, SIDNEY law.com, Lowell at sidneylaw.com. And this concludes this program brought to you by TimeSharing Today Broadcasting. At TimeSharing Today, your opinion really does count. So take a few minutes and send us your comments about today's interview. If you would like to participate in a future broadcast or suggest a topic for one, please send all comments to staff@tstoday.com. And until next time, happy time sharing.